The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me today are Justices Singh and D'Angelo. We'll be hearing this case, which is partially impounded, so please only use titles or initials, but no names. Each side gets 15 minutes. No one interrupts the other person. If one of the justices wants to ask a question, please do your best to stop talking and address the question. With that, this case is 21P 1031 LM versus WS. Mr. S, you get to go first.
That would be me. Well, good morning. Let me see, where do I begin? First of all, in the district court, in the Somerville District Court, I had originally requested for this matter to be expunged. Reason being is that the probation department couldn't correct their errors. They admit that there were errors in my, what I refer to as my civil BOP, Board of Probation. However, they had stated that that they could not comply at this time. There would be some sort of a failure for information to match across agencies' databases. It could cause broad disruption. Therefore, at this time, the probation cannot comply with my request to correct my carry. So they admit that there were errors. They could not correct my errors, so I requested expungement. Eventually, this matter came up to the appellate court. After they had submitted their briefs, 4 months later, after the submission of their briefs, they miraculously ended up fixing all the databases, it seems, throughout the Commonwealth of Massachusetts. They then corrected my civil BOP and submitted what they entitled Commissioner of Probation's suggestion of mootness, and where they corrected my civil BOP. However, although they corrected my civil BOP, there's still an issue with not being able to correct what I call a stay away, a support payment order on my second closed civil BOP order. I have an issue with that support payment order because I don't have any children. There's no way to correct this information. If you look at this case in its entirety right now, the probation department has finally fixed my issues, but this is beyond my issue. When it deals with case law, it deals with public importance, and it's capable of repetition, which is why I asked this court to now continue to look at this matter.
Can I just interrupt to make sure I understand correctly? The only thing that's before us is the 209A order, and you're telling me, if I understand correctly, that the records, as you call them, the civil BOP, now indicates that it was vacated.
Correct.
I see. Okay.
It does say it's vacated. There is still an error because on one of the orders on the civil BOP, it says that I had support payments. I don't want anyone, any criminal justice agency, looking at an error stating that I owe payments to a child and take that into consideration, for instance, on bail review and any other the numerous times a judge would do a search upon me: divorce, husband, abuse prevention order, child born out of wedlock, court releases, bails, discharge, pretrial detention. I don't want a judge to look at this wrong information and then determine to give me a higher bail, for instance.
No, I understand what you're saying, Mr. S. Was the mistaken support order, as you call it, was that before Judge Fitzpatrick in this case?
Was it? Yes. All this information it started in the district court. All this information is what they had. However, my issue now, if you look at it right now, the probation department has rectified the problem, if you will. But this problem is going to come up again and again, if not with me, with others, because one, there is no way to fix the error.
Mr. S, can I ask you, when you say there's a support order on your civil carry,
Yes.
is it still on the restraining order portion of your record, which now also says vacated? We're just trying to understand what you mean by that.
So what I'm trying to say is I don't have the original restraining order from 1995 from the Roxbury District Court. I don't have that, but I can tell you I don't have no children. So my argument now today is if someone, whether me or somebody else, finds information that is wrong, how do they go by correcting this wrongful information? What is the process of correcting this wrongful information? There is no process as currently, no due process. There's no way to fix this. So that's part of my problem now. Part of my other problem is this matter should have never been brought up to this court at this time. Back in the case of Vaccaro versus Vaccaro, the legislator had mandated the commissioner of probation to set up this registry, what I'll call domestic violence registry. I'll just call it the registry. And that was back in 1992. The commissioner advised the legislator that the system had been created and that the records would contain not only the data as to the original order, but also data on subsequent modifications. We now know that there was no subsequent modifications. All they had was open and close as a status code. As a matter of fact, in the SJC, it continues in Vaccaro versus Vaccaro on page 156, the department, or the probation department, suggests in its brief that the record in the system concerning George Vaccaro would reflect not only the entry of the temporary protective order of September 27, 1993, but also the fact that the order had been vacated. So they had stated to the SJC that they were actually marking down, modifying the civil BOPs to state vacated since 1993. We now know that that wasn't an issue. So all the people in the Commonwealth from 1993 to 2022 don't have the word vacated or anything else. All they have is the word open and closed on the civil BOP, which judges are now taking into consideration because they can't determine whether it was vacated or not, because it never stated vacated. So this not only affects me, it affects thousands of other people in the Commonwealth of Massachusetts. What is the probation department going to do? How are they going to correct their civil BOP? So this matter is beyond my case. It deals with the entire Commonwealth of Massachusetts at this point.
Okay, is there something else you'd like to tell us?
No, that's pretty much it.
Okay, thank you very much. Attorney Zhu, did I say it correctly?
It's Attorney Zook, Your Honor. It's like both.
Zook. Okay, go right ahead.
Thank you, and good morning, if it pleases the court. My name is Arthur Zook, and I am here on behalf of the Massachusetts Probation Service. Now, what the court has before it today is a petition to expunge a restraining order pursuant to the standard introduced in Commissioner of Probation v. Adams, indicating the very narrow circumstance where judges may expunge restraining orders if they find by clear and convincing evidence that there was fraud perpetrated upon the court. And in this case, the court should affirm the Somerville District Court's decision denying the petition because the appellant has not even attempted to show that this standard has in fact been met in this case.
Counsel, can I ask you about that? In all the cases that deal with expungement, the original restraining order has been found to be valid. In other words, that there was sufficient evidence and that the order was properly in effect. But later after that, the restraining order is closed, either because another judge found that there was insufficient evidence to extend it. This is different in this case. In this case, the order was not sufficiently issued according to our court. Doesn't that make this different than the cases that you've cited in your brief?
Well, Your Honor, what I would suggest is that it's not, because the standard is that very narrow standard where even if we're talking about a vacated order, Judge, it would still have to be expunged if there was clear and convincing evidence that fraud was perpetrated upon the court.
Okay, I'd like to go over some terms with you to make sure it's clear to me. If a plaintiff goes to a court, whether it be a district court or another court, to get a restraining order, and there's a hearing, and a judge does not issue a restraining order at that time, in other words, doesn't find there's sufficient evidence and the order does not issue, what shows up on that defendant's record?
At that point, nothing, Your Honor.
So nothing shows up. There's not even an entry that somebody was sought a restraining order against that individual. Is that correct?
Correct, Your Honor.
Okay. If a plaintiff goes in and seeks a restraining order ex parte and the order issues, and then 10 days later, a judge does not extend that order, what then shows up on that defendant's carry?
That there wasn't an order issued by the court, Your Honor.
And does it then say closed or vacated? Or what does it say?
Depending on what the, at that point, Your Honor, depending on what the court has ordered in terms of it not being extended, Judge, it would say closed at that point.
So is there a difference based on what the judge says at that time as to what probation enters on the record?
Yes, Your Honor.
Okay, can you explain that for us?
Well, in reference to what is said, Judge, there's orders can be closed if they are expired. Orders can be closed if they are dismissed, and orders can be closed if they're vacated, Your Honor. So there's the various options that we've added, as you can see from Exhibit A in our motion to suggest mootness. So it does depend on what occurs after the initial order is ordered and what happens after that, Your Honor.
All right, so at the 10-day hearing, if a plaintiff does not appear, what happens on the defendant's record? What does probation enter as what is the code? What does it say?
At this point, Your Honor, it would say closed and expired, Your Honor, because it expires after the 10 days, Your Honor, which is then why the hearing then would take place at that point.
All right, so now you're mixing in words here. I'm trying to make it clear for me as to exactly what it says. Does it say closed, or does it say expired, or does it say something different?
It would say closed, expired, Your Honor.
Oh, okay. So let's change it. A defendant and a plaintiff appear for that second 10-day date, and the judge does not extend the order. What does the record show in that circumstance?
Wait, Judge, so the plaintiff appear, I'm sorry, can you repeat that question? I apologize.
Sure, that's okay. Both parties appear and a full hearing takes place, and for whatever reason, the judge does not extend the order.
At that point, Judge, it would say closed, and it would say closed at that point, Your Honor, because it wasn't extended. Like a new permit was not extended.
So when does it say vacated? When does probation enter the code vacated?
If a party comes in and requests that it be vacated and then goes before the court, and the court does vacate the order at that point, Your Honor, and says it on the record and in the docket as well.
All right, I guess I am confused. I did restraining orders for 15 years, and I'm not sure when that takes place. So again, I'm going to try to go through the chronology. So after the 10-day date, a restraining order is issued for 1 year. Okay. The defendant 6 months later comes in and asks for a rehearing for some reason. And the judge has a new hearing. and the judge terminates the order at that time, maybe based on new evidence or whatever. Is that when it says vacated?
Well, if it's ordered to be vacated, yes, Judge. It wouldn't, like, it will be marked that it is vacated, Your Honor. And maybe I'm misunderstanding that question. I apologize, and I could follow up with a letter if you would like. If a judge does vacate the order, then it would mark that it would be vacated.
And maybe this is beyond what probation should be asked, but I'm going to ask it. When does a judge have the authority to vacate an order? I don't know what that term means in the world of restraining orders. What does vacate mean?
Well, Judge, so in a vacated order, under, I think, a scenario that you might be discussing would be that, let's say, a permanent order does issue, as you were talking about, on that 10-day emergency, the ex parte emergency order gets issued, and then another hearing takes place, and the judge does find that the order should be extended. And then at that point, some point later on, as it comes back and then does, whether the plaintiff or the defendant comes in to have that order vacated, that extension vacated, the court could order that based on whatever evidence is presented to the court at that time during that hearing.
Is there a spot on the restraining order where a judge has the power or authority to say vacated as opposed to terminated or closed?
Well, for instance, Judge, I'm not sure about that, and I can follow up with a letter on that exact thing on the restraining order itself. However, if the court does mark that it has been vacated on the record and in the docket, then at that point, it could be listed as closed and vacated.
I'm looking at a restraining order right now, and the only boxes that are available to a judge is, and this would be box E, if you have the restraining order at some point, it says prior court order terminated. This court's prior order is terminated. And then underneath that, there's another box that says terminated at plaintiff's request. And a judge signs it, dates it, and times it. So there is no box that I am aware of on a restraining order where a judge has, at least on the order, the power to vacate it. So I'm trying to figure out when the probation department knows to on the record to say terminated.
For terminated or vacated, Your Honor?
For vacated or terminated. Again, you're using terms that don't really seem to exist on the restraining order. You're saying closed, expired, vacated, and I don't see any of those terms on a restraining order. It's the only term here is prior court order terminated. So you told us earlier it's closed, expired, and now you've also introduced vacated. So I guess I'm trying to figure out, when does a judge have the authority to, quote, vacate, end quote, an order?
So if it is requested, Your Honor, orders have been vacated in the past by the courts on the records and on the docket. So the judges in those circumstances have in fact vacated the records. And a good example would be the MCD case, Your Honor, where again, at that point, the petitioner had filed an order to vacate and also expunge the 209A order in that, the 209A orders in that case. And again, it was listed again as vacated by the judge on the docket. And as you can see, like at that point, Judge, it was during that hearing on the petition to vacate that 209A and expunge it as well, where it was done, where the court did order it be vacated and expunged. I know it was eventually overturned. However, we're talking about the vacated portion of it, not the expungement, where the court did vacate that order after whether it was contested.
Vacation can also occur as a function of an appellate court, as occurred in this case.
Yes, Your Honor.
I'm sorry, I did not see your suggestion of mootness. I'm not sure if it's on the docket, to be honest. When did you file that?
That was July 21st, 2022.
Okay. And so that is correct. There's now a probation menu choice of vacated.
Yes, Your Honor, it says closed, vacated. At that.
Can you explain to me for example, what the law enforcement benefit exists for knowledge of a vacated order on the registry?
Yes, Your Honor. So, and that's the public safety portion that was discussed in Vaccaro v. Vaccaro. And what we see there, judges, it's because, again, these petition, 209A orders or restraining orders as a whole, to include the other orders that we have suggested in our brief, it allows the criminal justice agencies that are viewing these records in real time and get a full picture of, in fact, what is going on in terms of in terms of abuse, and there's that heightened degree of danger that can occur in these types of situations. So to view a vacated order is, again, to get an entire history of the case as it seems, as it happens in that particular case, as they're making those real-time decisions, Your Honor.
And the registry under the Enabling Act has to keep track of orders that are issued regardless of what happens to them. Is that correct?
Yes, Your Honor, unless they are expunged through that one narrow circumstance. Right. Correct, Your Honor. All the orders, and I'm sorry, I implied, I just meant to say that vacated orders as well are right in there, and they're not designated as expunged for that reason. So they because
the legislature spoke in terms of issuance.
Correct, Your Honor.
So probation doesn't take any difference when an appellate court says that the order should never have been issued. They take no difference between that and an issued order that is then closed.
Well,
in this case, the appeals court said that the original order, the ex parte order, there was insufficient evidence and it should never have been issued in the first place. Correct?
Correct, Your Honor.
So the probation department takes no difference between that order that should never have been issued and an order that was properly issued and then closed. The probation department doesn't see any difference in that situation.
No, Your Honor, because we're following the acts of Chapter 188 of the Acts of 1992 that mandates us to have that registry in place, Your Honor.
And just to make it clear for me, if a plaintiff comes into court and an order never issues in the first place, nothing shows up on the defendant's record in that situation.
Oh, correct, Your Honor. An order has not issued at that point.
Okay. Thank you.
And at this point, I'm happy to take any more questions. And if there are no questions, I'm happy to rest on the brief that's submitted.
Seeing none, thank you. Thank you both. We'll take this under advisement.
Thank you, Your Honors.